This episode is about music copyrights in 2026 regarding athletes licensing music for their content creation. Imagine winning an Olympic gold medal. You've trained for your entire life for this moment. You step off the ice, your country is cheering, and within hours, a musician is publicly calling you out because his song aired all over the world without his permission. That is exactly what happened to American figure skater Amber Glenn at the 2026 Milan Winter Olympics. It went viral, 13 million views on a single post, and it sparked a conversation about one of the most legally complicated areas in all of sports, music licensing. Today, we are breaking down why music rights in sports are so complex, what the actual legal consequences can look like when things go wrong, and what every athlete and content creator needs to be thinking about before they use music in any context. I'm Stevie. This is Girl Code of Law. Let's get into it. A quick note, everything I share on this channel is legal information and commentary. It's not legal advice. If you need specific guidance for your situation, please consult a licensed attorney in your jurisdiction. Amber Glenn won gold in the figure skating team event on February 8th, 2026. That same evening, Canadian artist Seb McKinnon, who records under the name Clan, posted to X saying he just found out an Olympic skater used his song The Return without permission. It had aired worldwide. He asked publicly, "Is that standard practice for the Olympics?" The post exploded, over 13 million views, and here is what I want to be clear about. This did not become a lawsuit. McKinnon and Glenn resolved the situation within days. Glenn acknowledged there had been a hiccup in the licensing process. McKinnon then congratulated her on the gold. So why are we talking about it? Because the fact that it resolved amicably is almost besides the point. The licensing failure was real. The international broadcast happened without the clearance of the music, and the exact same situation at previous Olympics did not resolve amicably. In 2022, in the Beijing Olympics, American pairs skaters performed to a cover of House of the Rising Sun. After the games, the rights holders sued. And that lawsuit also named NBC for broadcasting the performance. It settled for an undisclosed amount, but sources suggest it may have reached into the millions of dollars. For athletes whose prize money is measured typically in the thousands, a settlement like that can be career altering. Both of these instances happened in Olympic figure skating. Same type of licensing failure. Completely different outcomes because the rights holders decided to pursue legal action instead of having a conversation. You cannot build a strategy around hoping the artist is going to be understanding. Let's get into the legal architecture of this because this is where most athletes and their teams go wrong, and it often leads to trouble. Copyright in music is not one right, it's multiple rights. When you use a song, you're potentially dealing with the composition copyright, which is the actual formation of the music. If you think of sheet music, the notes and the words on the page, which is typically owned by a publisher or songwriter. And then there's the master recording copyright, and that's a specifically recorded version, typically owned by a label. And you need different licenses depending on what you're doing with the music. A performance license covers a performance of the music, whether a recorded version or a live version being played, like a cover. A synchronization license, a sync license, covers pairing the music with visual content, like a movie. A broadcast license covers transmitting that performance over television or streaming. These are separate agreements and typically are negotiated separately. Clearing one does not automatically clear the other licenses that may be needed. Now apply that to the Olympic performance. The athlete performs a routine to the music playing. Performance license. NBC broadcasts in the US, broadcast license. International partners in 40 plus countries, that's separate licensing requirements for each. A social media clip goes viral, potentially another set of rights issues entirely. Skaters use a platform called Click and Clear to manage this, but Click and Clear can only coordinate the licenses it has access to. And as 2026 has showed, gaps still remain. And crucially, U.S. figure skating's own policy is that the ultimate responsibility lies with the skater and their team, not the skating federation, not the ISU, the athlete. McKinnon's situation adds another layer of complication. His label contract gives him and only him personal authority to approve licensing. Even if a platform or licensing service thought they had clearance through the label, they may not have actually had it. That kind of artist-controlled contract is increasingly common and increasingly important for clearance purposes. Now, I want to take this beyond figure skating because this concept matters for content creators and also especially for athletes who create content, which is basically every athlete building a brand in 2026. NIL rights gave college athletes the ability to monetize their name, image, and likeness. That is a real and meaningful legal shift. But those rights did not come with music licensing tutorials. And music in content is one of the most consistent ways athletes accidentally create legal exposure for themselves. When you post a training montage with a song in the background, that's a copyright issue. A highlight reel set to music, copyright issue. A celebration video after a win. If there's a recognizable music anywhere in that video, you're potentially infringing on that copyright. And here's why this specifically matters for NIL. Your content is your brand. Brands look at your socials before they sign you. If your content is getting muted, flagged, taken down, that all affects your professional presentation. If you have an active name, image, and likeness deal and your branded content gets caught in a copyright dispute, that creates complications with your brand partner and potentially the deal you have with them. The Amber Glenn story ended well. The Beijing story did not. The difference was largely relationships and goodwill, not law. And you can't build a legal strategy on hoping that a rights holder is going to be nice about a violation of their rights. Share this with every athlete and performer in your circle who creates content or competes with music. This is exactly the kind of thing that nobody tells you until it's already a problem. And if you want to understand how AI is creating an entirely new layer of threat to athlete identities and NIL rights specifically, that video is coming next week. I'm Stevie. This is Girl Code of Law. I'll see you then.